Avoiding unintentional poison pill provisions when entering distribution and other business transactions. Intended for entrepreneurs and the attorneys representing startup clients, this slideshow is intended to help the company avoid terms in licensing, distribution and other agreements that could make the company unappealing to a potential acquirer later on. Poison pills are contract provisions intentionally adopted by management to make a company unattractive to a prospective acquirer. These measures are typically adopted by the officers and shareholders of companies to prevent them from becoming targets for acquisition. In the technology sector, however, venture capitalists and other early-stage investors are often actively seeking a large corporate acquirer as a source of liquidity and to realize a return on investment. Nevertheless, if a startup has inadvertently committed to contractual provisions in its transactional agreements that reduce the appeal and value of the company to a potential acquirer, these provisions can create poison pills unintentionally. Issues arise in the following three areas: disputed or divided ownership rights of intellectual property or other assets, disputed or divided distribution rights for products and technologies, and liabilities, including potential claims from customers, suppliers, IRS tax liabilities, and other parties to contracts. In the coming slides, we'll identify some of the offending provisions and offer advice to founders and managers of early-stage technology development companies to help preserve the value of their technology assets and maximize the company's appeal to corporate acquirers. Innovative new technologies are best developed in small, independent startups, but they're often best commercialized by large corporations with deep pockets and established routes to market. In many sectors, assembling a team, raising investment, and creating a new product or technology is very much easier than establishing a route to market. The biggest obstacle facing many early-stage developers is establishing an effective channel to market. Although a small percentage of companies are able to establish their own direct sales channels, most developers are forced to enter into a variety of transactions with third-party companies if they want to establish channels to market. These arrangements include distribution arrangements, whereby the distributor sells the product through its network of channel partners, reseller agreements where the reseller sells the product direct to customers, OEM agreements where the product is embedded into those of the partner, and technology licensing agreements where the technology is licensed for distribution in a specific field of use. Although many third-party channel options may be available, one of the most effective and profitable routes to market is for the startup to sell the technology to a large corporation that is on the lookout for new products and revenue streams. It's commonplace for large technology corporations like Cisco, IBM, Intel, and Oracle to acquire the company and then leverage their own channels to bring the new products and technologies to market. So what are these corporations looking for when they make an acquisition? Outside of the technology sector, most acquisitions are driven by cash flow. The buyer is interested in the cash flow that's generated by the seller and wants to consolidate this to its own financial statements. Many acquisitions in the technology sector are driven by the acquirer's interest in the seller's intellectual property assets. Cash flow alone would fail to justify many of the acquisitions that are made in Silicon Valley. Many of the corporate acquisitions are really technology transfers, so the technology ownership and distribution rights come under intense scrutiny. Although all contracts should be carefully prepared and scrutinized with care, here are some of the types of agreements where offending provisions may arise. Outbound channel agreements. including technology licensing, sales contracts, OEM distribution and reseller contracts. Inbound agreements, including inbound technology licensing agreements, non-disclosure and confidentiality agreements, consulting and manufacturing agreements. Then there are investment agreements, including the preference shares and convertible notes. And finally, employment agreements, especially those of officers and executives, engineering and product development employees. Protective measures are adopted by buyers. Corporate acquirers are generally looking to obtain clean title to valuable assets without incurring liabilities in the process. In an ideal world, insurance would be available to indemnify the buyer from any liabilities resulting from a merger or acquisition transaction. But this is not possible in view of the extensive range of liabilities and the issues that can arise. The protective measures that are typically taken by buyers are due diligence and transactional structures such as triangular mergers that attempt to extract the assets from the target company and strip out the liabilities in the process. In terms of due diligence, prior to closing the transaction, a corporate acquirer conducts a thorough review of the target company's contracts and documents in order to determine the value of the assets and the risks posed by the potential liabilities. The due diligence process can take several months and include reviews of the following documents: inbound and outbound contracts, including channel-related distribution agreements, company organizational documents, including the Articles of Association and bylaws, litigation activities, including previous and pending lawsuits, employee issues, including employment contracts, benefits, the company handbook, etc., tax matters, including filings and disputes with the tax office, intellectual property, including patents, both foreign and domestic, patent assignments from employees and contractors, licenses, trademarks, service marks, domain names, copyrights, and infringement claims. If we're dealing with an asset acquisition, one simple way for the acquirer to buy the assets without inheriting the potential liabilities is to structure the acquisition as an asset sale. Although ownership of the technology and other assets is transferred from the target to the acquirer, in this type of transaction, the target corporation itself is not acquired, and it continues to exist as an independent corporate entity. This may be an effective protective measure for the acquirer, but it is highly unappealing to the shareholders of the target corporate acquirer, as it exposes them to double taxation. They pay tax at the corporate level on the asset sale, then they pay tax at the personal level on the dividend from the corporation, distributing the proceeds to the shareholders. For this reason, asset acquisition is often not an option that's acceptable to the target company. In terms of triangular mergers, if the acquirer creates a subsidiary and uses this as a vehicle to take ownership of the target's assets and strip out some liabilities, this is known as a triangular merger. The tax costs of a triangular merger are not as harsh as those of an asset sale, so it's a structure that's often used for acquisition transactions in the technology sector. Triangular mergers do not strip out all the liabilities from a corporate acquisition, and they cannot resolve disputes over ownership of intellectual property and distribution rights. So this is a measure that startup developers can expect their acquirers to suggest. Triangular mergers, asset sales, and other structures will not relieve companies from the detrimental effects of unintentional poison pill provisions in their contracts. They can safely assume that such provisions will be discovered in the due diligence process. If the company is looking to be acquired it must consider, when entering license agreements and other contracts, that the scope of the acquirer's business is likely to be much more expansive than that of the company. Large corporations are generally involved in a wider range of activities than small startups. So when negotiating agreements, the startup company should ensure that the scope of in-license grants and other arrangements should be as wide as possible, providing the company and the potential ultimate acquirer with rights that are as extensive as possible. It's also important to restrict the scope of out-license grants. Although the startup company, may not be concerned about licensing rights to fields of use that are outside the scope of the company's business today, the acquirer may be disappointed if the company has sold license rights to fields of use that would be of interest to the acquirer. This is one of the scenarios we're envisaging in this slideshow. Company C has employees, has inbound technology licensing agreements, outbound technology licensing agreements, and has agents and employees assigning patents and other rights to the company. Investors in the company are ultimately interested in selling the business to a corporate acquirer in order to achieve a return on their investment. Imagine corporate acquirer A is locked in battle with a direct competitor, distributor B, and is looking to acquire company C in order to win exclusive distribution rights to company C's products. Company C has a distribution arrangement with distributor D. The nature of this distribution arrangement could be of significant interest to corporate acquirer A as it evaluates the potential acquisition. If distributor D has the ability to assign its distribution rights to distributor B, there's a possibility that corporate acquirer A could acquire company C for a significant sum, but then find its competitor, distributor B, can acquire distribution rights from distributor D at much more modest cost through assignment. The assignment provision could prevent the acquirer from being able to acquire exclusive rights and prevent its competitor from distributing the same product. In the coming slides, we will outline some steps the company can take in order to avoid harming its prospects of selling out to corporate acquirer A in our scenario here. The first piece of advice for companies entering licensing or distribution agreements is to hire a lawyer. Many of the issues identified in this slideshow are somewhat alien to the average technology developer or entrepreneur. When transacting business with larger customers, distributors and licensees, the startup entrepreneur finds himself negotiating across the table from experienced corporate attorneys and agreeing to provisions in contracts that he doesn't properly understand. Without access to a lawyer with experience in technology transactions, it would be very difficult to prevent the startup from inadvertently adopting one or more poison pill provisions. Hiring a competent lawyer can be critically important to preserving the value of a technology startup. Make the break clean. Corporate employment agreements generally include provisions assigning the rights of inventions created by the employee to the employer for the duration of the employment. If the employee resigns and forms a new startup that subsequently develops an interesting new technology, there's a possibility that the previous employer will create a claim against the new startup, disputing ownership of the underlying idea or invention. If the idea was formed and developed after his resignation, the employee has little to worry about, as the court would likely rule that the previous employer has no valid claim. However, the previous employer may well win a judgment if the employee spent a period of time developing the idea while he was still in the employ of the previous employer. Ideas that are developed on the employer's time, using the employer's computers, laboratories, office facilities, they generally belong to the employer. In California, courts respect the rights of individuals to earn a livelihood from their work, and they generally rule that employees own the rights to the inventions that they develop in their own time, using their own resources. In the ideal scenario, the employer will provide the employee with provisions in the termination agreement, releasing the employee from any claims or disputes. However, this is unlikely to be achieved unless he has an unusually strong bargaining power. So the advice to startup entrepreneurs in making the break from their employers as clean as possible is that they should avoid commingling their own personal ideas and technology developments with those of their employers. This generally means using separate office facilities and equipment, such as computers, telephones and PDAs, and maintaining a logbook detailing where and when work was carried out, and clearly showing such work was not performed on company equipment or company time. Limit liability. In exchange for providing rights and privileges, a contract creates responsibilities and liabilities for each of the parties. Excessive liabilities are unappealing to potential corporate acquirers, and contract attorneys spend a good deal of their time negotiating how they can minimize the liabilities when transacting business. The limited liabilities clause is often the first place a contract attorney looks when reviewing an agreement, as it sets a parameter around the degree of risk to which the company is exposed. In technology agreements, it's not unusual to have the parties waive their rights to consequential and punitive damages. This is very important as the costs resulting from these claims can be very significant. Imagine the case of a large corporate customer licensing payroll software from a startup for a price of, say, $10,000. If the software fails to perform, the customer could sue the startup for breach of contract, recover the $10,000 cost, and then demand recovery of lost profits and other consequential damages totaling several $1,000,000. If the startup negotiates a waiver of consequential damages in the contract, it can drastically limit its liability and exposure to subsequent claims. It's not surprising that software developers almost always require licensees to waive their rights to consequential damages and restrict the damages to a refund of monies received from the customer. Another technique that's often employed is to define the damages using a liquidated damages provision. This specifies precisely what the damages will be in the event of a breach. Very popular in construction contracts for defining the cost of delayed projects, this term can be used effectively in the technology sector to restrict the scope of damages. By defining the maximum dollar amount of damages that could be recovered by the customer from a breach of the contract, the company can limit liabilities resulting from the contract. Assign employee ownership rights to the company. Patents are generally issued in the name of the inventor and are then assigned to the employer. If the patent is not assigned, ownership rights can be disputed, as it can be subject to a claim of ownership by the inventor-employee. The issue is not restricted to patents. Disputed rights to copyrights, trade secrets, trademarks, and other forms of intellectual property can seriously damage the value of a technology company. So it's good practice for startups and other employers to force their employees to agree to provisions in their employment contracts, assigning the rights to intellectual property developed by the employee within the scope of employment to the employer. Assign contractor ownership rights to the company. Early-stage technology companies often outsource as much of the research and development activities as they possibly can. By contracting this work out, the company can keep its core team of employees as small as possible. Maintaining a small, nimble team is vital for a startup to compete with large corporate competitors. To protect the company from intellectual property ownership disputes from contractors, it's important to include an ownership of work product provision in all inbound consulting contracts that clearly assigns ownership of the intellectual property created by the contractor within the scope of the consulting project to the company. Prevent breach of third-party ownership rights. Typically, a developer licensing its technology to a customer will agree to indemnify the customer from any claims that the technology breaches the intellectual property rights of a third party. The startup normally agrees that it will pay for the costs of defending a case brought against the company by a third party. The most common example is a patent infringement suit, and that it will refund the cost of the license or find a suitable remedy in this situation. Such an indemnification clause and a subsequent suit could expose the startup to an enormous amount of liability, especially if the customer and the third party claim loss of profits. So in addition to negotiating a waiver of consequential damages clause, the startup is well advised to take whatever measures are reasonable to make sure it does not in fact breach the ownership rights of third parties. This could involve carefully tracking the USPTO patent database for potential patent infringements and making sure the company does not exceed the scope of its own inbound technology licensing agreements. Scrutinize outbound license assignments. An assignment is the transfer of rights held by one party to another. Assignment clauses in technology license and other agreements can cause concern for potential acquirers. Broad assignment rights provided to the company can be appealing to the acquirer. Broad assignment rights provided to others by the company can be unappealing to the acquirer. It may be in the company's interest to have the ability to assign the rights it acquires through distribution and out-licensing transactions, as this could help facilitate the acquisition transaction with the corporate acquirer. So the assignment provision can be beneficial to the startup in a merger or acquisition, but not in a distribution or licensing transaction. For this reason, it may be in the startup's interest to word an assignment provision in a license agreement in such a way that assignments are restricted, except for certain situations such as mutual agreement and merger or acquisition. In the scenario of mutual agreement, the assignment is proposed by one party, but is not effective unless approved by the other party. This would restrict the other party from assigning its rights without the approval of the company. In the scenario of merger or acquisition, the assignment is allowed in the case of a merger or consolidation of the company, in which the company's shareholders do not retain a majority of the voting power in the surviving corporation, or a sale of all or substantially all the company's assets. This would allow the company to assign its rights to a corporate acquirer as part of an acquisition transaction. It may not be entirely necessary to facilitate the acquisition of the company by the corporate acquirer, but it may offer the merger and acquisition lawyers more scope for alternative ways of structuring the transaction. Limit the term of distribution rights. When entering distribution agreements for major markets, the term of the agreement will be negotiated. The distributor will want the term to be as long as possible. Ideally, they'd like the distribution rights to be perpetual. If distributor B has rights to distribute the company's technology in perpetuity, and the termination clause does not provide the company with the power to terminate, there's little or no incentive for corporate acquirer A to acquire the company. This is a good example of an unintentional poison pill provision. The term and termination clause of the company's distribution agreement with distributor B may appear to be innocuous. In fact, it may appear to be of benefit to the company in that it provides a valuable route to market. However, without a termination date or ability for termination at the company's option, this provision prevents corporate acquirer A from winning a competitive advantage by acquiring the company and reduces the value of the company in an acquisition. As distributor B has rights to distribute the company's products in perpetuity, distributor B also has little or no incentive to acquire the company. The term and termination clause in its distribution agreement has trapped the company into a distribution agreement and virtually eradicated its value to a potential acquirer. The solution to this problem involves the company setting a reasonable term to the distribution rights that it assigns in its sales and marketing transactions, or retains the option of terminating the agreement within a relatively short period of time. If there's a possibility of the distributor acquiring the company at some stage in future, the company should bear in mind that the distribution agreement could be a try the product before you buy the company transaction, and structure the term and termination provisions accordingly. Limit the scope of licensing grants. The scope of the target company's business is likely to be significantly more narrow than that of the acquirer. The startup company's own business may be restricted to certain types of customers and markets in California, say, so it may see no problem in assigning exclusive distribution rights to distributor D for certain fields of use and market areas such as Asia. If corporate acquirer A has a global perspective and sales, marketing and distribution capabilities in Asia, the scope of the distribution rights that the company assigned to distributor D could reduce the value of the company from the perspective of corporate acquirer A. The arrangement that the company entered into with distributor D could jeopardize a potential acquisition by corporate acquirer A. For this reason, it's important for developers and entrepreneurs to limit the scope of licensing grants to the bare minimum and restrict the rights to only those the distributor actually needs. Scrutinize inbound licensing restrictions. As mentioned on other slides, the scope of the acquirer's business is likely to be much more expansive than that of the target company. Field of use restrictions that are acceptable in inbound licensing agreements may be acceptable to the target company, but unpalatable to the acquirer, as they may restrict the acquirer from leveraging the full capabilities of its sales, marketing and distribution channels. So when entering inbound licensing technology licensing agreements, the company developers should negotiate license grants that maximize the scope of the fields of use as far as possible, even beyond what the company sees as the potential scope of business today. Protect the company's trade secrets. Trade secrets can provide a company with a competitive advantage and enhance the value of the company from the perspective of a potential acquirer. Unlike patents and copyrights, trade secrets are not restricted to a limited lifespan. Trade secrets do not pass into the public domain automatically after a period of time. However, they lose their value and cease to have the support of the courts if they're not carefully protected. So if PepsiCo failed to take sufficient measures to protect the recipe for Pepsi-Cola, it would lose its ability to have the recipe protected in court as a trade secret. Competitors could gain access to the recipe, and it would eventually become part of the public domain. As venture capital investors and many other types of organizations refuse to sign non-disclosure agreements, technology entrepreneurs could be exposed to the possibility of disclosing their trade secrets when raising funds and promoting their startups. It's important for startup companies to take care when preparing business plans, investor and other presentations to ensure that they don't find themselves divulging trade secrets. Presenting the company, its technology, and competitive advantage without revealing trade secrets is a skill that entrepreneurs and developers have to learn. If a corporation can obtain the trade secret, the secret source, from the public domain, there may be little incentive for it to acquire the company. Control covenants. A covenant is merely a legally binding promise. Entrepreneurs sometimes agree to covenants that appear to be harmless to a startup, but they're considered hazardous to a potential corporate acquirer. It's not unusual, for example, for a distributor or licensee to request the company covenant that it will not compete in a specific market sector. The startup may be presented with justification along the lines of, "I agree to distribute your product to my customer base, but you have to promise that you will not compete with me." Although the startup has no intention of competing in this sector, a large corporate acquirer may well compete with a distributor, and this type of covenant could raise flags of concern in the acquisition due diligence process. Another example could be where the distributor requires most favored customer status, and the company covenants that it will always provide the distributor with terms and prices that are at least as appealing as all its other clients. This may contradict the strategy of the corporate acquirer. It is important for technology developers to take care and control the covenants it commits to in its business development and other transactions. Restrict warranties. Warranties are binding guarantees. They provide assurances to customers and third parties, but create potential liabilities. Potential liabilities concern acquirers and often scupper otherwise appealing merger and acquisition deals. Breach of warranty can lead to significant damage claims that include consequential and punitive damages. It's good practice for all companies, including technology startups, to restrict the scope of the warranties they provide to their customers, licensees and other parties with which they transact business. It's important for developers to define the warranties they provide to their customers and business partners as restrictively as possible, limiting the potential liabilities to levels that are acceptable to a potential acquirer. Inspect investment terms. Venture capitalists and other investors in technology startups often demand terms that protect their interests and may appear to be acceptable to the company, but raise concerns for potential corporate acquirers. Preference share agreements include many provisions protecting the interests of investors, but most of these issues disappear when the company is acquired and the preference shares are sold. However, some of the terms should be carefully considered by entrepreneurs, as they may affect the company's and the employees' rights in an acquisition. The liquidation preference terms effectively define how the proceeds of a sale of the company are distributed between the investors, the founders, and the employees. If the vast bulk of the sales proceeds, or all of them, go to the investors instead of the employees, this could create a crisis of morale in the team. The acquirer could understandably be very concerned about the prospect of buying a company and inheriting a team that's reluctant to complete the acquisition and disappointed in the financial results of their startup efforts. This can be a real problem for acquisitions of technology startups, where the expertise of the team is vital for the successful deployment of the technology. Another area of concern could be investor claims over technology and other assets. Some investors force their companies to assign them rights to technologies under certain conditions. If these claims are not released on or before closing of the acquisition, they could seriously reduce the value of the company from the perspective of the acquirer. So startup entrepreneurs and developers should be advised to inspect investment terms very carefully in order to maximize the value of the company in an acquisition. Restrict representations. A statement of fact made during the negotiation of an agreement can constitute a representation that the other party relies upon when entering into the contract. If the statement is found to be false or not entirely accurate, then the party that relied on the representation can claim damages if it can show that such reliance was detrimental to its business and that reliance on the statement was reasonable under the circumstances. Liabilities of this type are something of a concern for potential acquirers. Entrepreneurs and startup developers often find themselves inadvertently making representations that have the potential to open their companies up to liabilities in future. Take the example of the startup that enters into a technology licensing agreement and makes the statement to the licensee that the market for this technology is worth $10 billion. This may appear to be an innocuous statement and simply part of an overzealous sales presentation. However, if the licensee can show that it entered into the contract on reliance of this claim, and that the claim was found to be untrue, the market was much less than $10 billion, then the licensee may assert in court that it suffered detrimentally from the representation and it can claim damages as a result. The advice to the startup entrepreneur is to keep the representations to a minimum and make sure that the statements that are made are fully supported by facts. Perhaps one of the best techniques for achieving this is through a merger or integration clause in the agreement, stating that the written agreement replaces all previous agreements and discussions, both written and oral, and constitutes the entire agreement between the parties, or something along those lines. This excludes any claims or statements that may have been made in the negotiation process from the agreement. Any representations that are necessary are then written into the agreement. They're controlled and can be verified before the contract is executed. In this way, representations and the resulting liabilities can be restricted to a level that's acceptable to a potential acquirer. Avoid golden parachutes. When a large technology sector corporation, such as Cisco, Intel or IBM, acquires a small startup, its primary interest is generally in acquiring the technology and the team on which the technology relies. Typically the product design and engineering team. These large organizations usually have their own CEOs, their own management teams, sales, marketing and distribution channels in place already, and they view the target corporation management structure in the target company as simply a disposable wrapper for the technology and the engineering team. So following an acquisition, it's not unusual for members of the startup's team that are not necessary to the continuing development of the product to be laid off. The CEO and senior management of the startup that's acquired may be the first to go, and this could cause a problem for the acquirer if these executives have employment agreements that include golden parachutes, involving large amounts of severance pay, stock options, and a bonus for the executive when laid off. Golden parachutes are often deliberately set in place as poison pill provisions to prevent a hostile takeover. Unless they're carefully constructed and easily terminated, golden parachutes can be equally effective at preventing takeovers that will be welcomed by the founders of a technology startup. The ideal solution is to avoid golden parachute provisions in employment agreements altogether. If they cannot be avoided, the company is advised to retain the option of eliminating the offending provisions in the case of a friendly takeover that's welcomed by the majority of the shareholders. In summary, entrepreneurs and the attorneys that represent them when negotiating distribution, licensing and other agreements are advised to think beyond the immediate contract. Prepare the contracts and documents, bearing in mind the future due diligence by a potential acquirer. They should avoid disputed ownership rights, avoid disputed distribution rights, and where possible, avoid liabilities. And avoid unintentional poison pill provisions that reduce the appeal and value of the company to a potential acquirer.